We have instructions to move to the High Court with speed to challenge that decision. One, the punishment is excessive. It is oppressive. It is not what the evidence produced in court was supposed to be. It is a punishment that was for the purpose of BBC. So we shall be moving to the High Court to challenge sentence. Two, we shall also be moving to the High Court to challenge the finding of guilt, because the evidence produced exonerated our client. But we are not going to keep quiet. We shall challenge that decision. We shall see to it that justice is done. We'll be determined to move to the High Court, to the Court of Appeal, and even to the Supreme Court. Remember, the jurisprudence now on criminal law from the Muruatetu, the final destination is the Supreme Court. So the defense team is determined to knock the doors of the Supreme Court to ensure that our client is free, our client is released, and our client does not get confined because of the public pressure. That's it.
Yes. Good afternoon.
For the first convict, my name is Dan Samari, together with Martina Suka.
Present, Your Honor, good afternoon.
Good afternoon.
Shanice Maindi, MS.
I'm calling for this case.
Shanice.
Maindi.
Good afternoon, Your Honor.
Good afternoon.
My name is Amasa. I do appear for the second call.
Sentencing, the fact understand the offence. In summary, in regard to the second convict, it began by asking the court to exercise discretion in sentencing. She is a first offender. She is religious. She has religiously attended court and carried herself with decorum. She's a person of good reputation, and her neighbors were shocked on her conviction. She is passionate on her work and hardworking. She has clean records at Mama Lucy Kibaki Hospital. She has always observed the code of ethics in the said institution. She was a reliable, or she's a reliable person in the community. She has carried charitable activities in kind. She's a mother of two minors, that is 8 and 12 years old. These two minors have always depended on her to prepare them to school and also assist in the demanding CBC curriculum. Her husband, who is a security officer, has had to leave his duties to attend to the children during the time pending sentencing. She lost her job, which she depended on to manage her family and also the extended family. She prays this court consider non-custodial sentence, and she will also need counseling guidance to address her psychological needs, since she's in self-denial, and the only remedy would be non-custodial sentence. The mother, the family has lost a mother, a daughter, a wife since conviction. In response by the prosecution, it was noted that he would need a deterrent sentence. The prosecution was also surprised how the accused, the first convict, him to comprehend the offense. report by the probation officer was negative on non-custodial sentence in regard to the first convict. In regard to the second accused and or convict, the prosecution appreciates that she was recommended for non-custodial sentence. She is also remorseful litigation submissions by the judiciary bail bonds policy. And I must mention that as stated by the prosecution, as stated by the other parties, sentencing is a discretion of the courts. And I relied on one case among many others, the case of Francis Daramba. The Court of Appeal noted as follows: sentencing is a discretionary act of the trial court, even though the limits such as maximum sentence and in some cases the minimum sentence are prescribed by the law. Nonetheless, as the exact sentence to be pronounced upon conviction upon a convicted person, the trial court has in most criminal cases the discretion to decide. The judiciary sentencing policy guidelines sets out 6 objectives of sentencing as follows: retribution, deterrence, rehabilitation, restorative justice, community protection, and denunciation. The judiciary policy also on sentencing goes ahead to put out issues of consideration when sentencing, and it is proper for the court before sentencing to consider aggravating circumstances surrounding any offense that would warrant a stiffer penalty that ordinarily would not have been imposed in the absence of the same. And I picked a few of aggravating circumstances for the court to consider in sentencing, and this would include where there are multiple victims, grave impact on national security, serious physical and psychological effect on the victim, targeting of vulnerable groups such as children, elderly persons, and persons with disability, intricate planning of an offense, and intention to commit a more serious offense than what actually committed, high level of profit from the offense, an attempt to conceal or dispose of evidence, abuse of position of trust and authority, use of grossly inhuman or degrading means in the commission of the offense. As I said, indeed, sentencing is an important task in a matter of crime as held in the Court of Appeal in Thomas Mambu Wenyi versus Republic, and also as quoted of the decision in the Supreme Court of India, it was committed. Further, it must be appreciated that the common thread in sentencing is discretion of the to be exercised judiciously and not capriciously. A felony, that is trafficking in person, further trafficking in person, and child neglect. The second accused or convict was convicted of offense of neglect of a child. At this point, I rested and asked myself, what are the issues? Are there issues or are there aggravating circumstances that would warrant a stiffer penalty than would be ordinarily imposed in their absence? There is no doubt that the offense included multiple victims, that is, children aged 8 days to 3 weeks. The offense of human trafficking is now an emerging trade and a transnational organized crime which has a grave impact on national security. The victims in the offense, who were minors, were exposed to abuse and human trafficking by the convicts, whose main role was to protect them. After exposure to trafficking, the victims have suffered serious physical and psychological effects. One of the victim died after a few months. He was admitted at Imani Children's Home. As stated in the judgment, the first convict used legitimate transfer of victims, knowing that after they leave Mama Lucy Kibaki Hospital, no one would follow to ensure they arrived at Imani Children's Home. The first convict or accused targeted the vulnerability of the three voiceless minors. He was involved in intricate planning of the offense, as demonstrated in various meetings between himself and the purported buyer in Quos Ross. As per the discussions in the BBC documentary, the first convict had all intentions to commit more serious offenses than would actually committed, or more serious offense than would actually commit. He went on to discuss of selling of one child, particularly baby boy, but gave out two other more in a legitimate baby transfer. He seemed to have indulged into high-level profits from the offense. He received 300,000 shillings from trafficking one victim. He even attempted to conceal or dispose of evidence by failing to update the children officer of the children admission and discharge at Mama Lucy Kibaki Hospital. The two convicts abused their position of trust and authority as medical social workers at Mama Lucy Kibaki Hospital, whose main call of duty is to protect vulnerable children, among other duties. The first convict used grossly inhuman and degrading means in the commission of the offense of human trafficking and child neglect. Notably, the court is persuaded that the offenses under which the accused persons are facing the prescribed sentence, the word liable is used. The court was guided by the case of Daniel Chalo Mwema in the Court of Appeal, where it stated that the word shall be liable do not, in their ordinary meaning, require the imposition of the stated penalty, but merely express the stated penalty which would be imposed at the discretion of the court. In conclusion, I am satisfied that there are aggravating circumstances around the commission of the offense stated above. In sentencing, I have considered the mitigation by the defense as well. The convicts are first offenders. Although first convict apologized through his lawyer, it has been stated that he holds a diploma in medical social work, and he has worked for several years. He ought to have appreciated the gravity of the offense. It is a finding of the court and the probation. It is a finding of the probation officer that he is not remorseful. He lacks empathy for others. It was noted that he was not truthful in his testimony, even for the obvious issues in the documentary, in the BBC documentary, and the same was noted by the probation officer. He is not likely to be rehabilitated in the community, and therefore he deserves a deterrent sentence owing to the aggravating circumstances surrounding the offense. And therefore, I would exercise my discretion and sentence the first accused or the first convict as follows. And the first convict will be sentenced to serve custodial sentence of 3 years on count 1 of conspiracy to commit a felony, that as a trafficking in person. In count 2, 3, and 4, the accused person will serve imprisonment of 30 years. In count 5, 6, and 7, he will serve a sentence of 2 years. The second convict, who is a first offender, will be sentenced to serve an uncustodial sentence, and the court will exercise discretion and give him a penalty of 100,000 shillings into 2 years imprisonment on each of the charge of child neglect. I wish to elaborate on the sentencing of the first convict. I wish to elaborate further on the sentencing of the first convict. Sentencing for each similar offense shall run together. Sentencing for each similar offense shall run together. That is for count 2, 3, and 4, the 30 years will run together. For count 5, 6, and 7, the 2 years will run together. And further to that, the first convict is a first offender, and I will also exercise further discretion and say as follows. The first convict will serve 25 years in custody, 25 years in custody, and for purposes of reintegration back to the community, out of the 35 years pronounced in his sentence, he will serve the remainder of 10 years under probation sentence, which will be, he will be put under close supervision. Further to the sentence, I hereby order that for the period the two shall be, for the period of the sentence, the two convicts shall not be assigned duties related to children welfare. The two surviving victims are now available for legal adoption to enjoy a nuclear family setting. I also order the release of records produced in respect of the victims to the management of Imani Children's Home to facilitate adoption as the case might be. Each accused person or convict has 14 days right of appeal.
The proceedings the judgment and the sentence. To enable us proceed as instructed by the first convict. Third, Your Honor, the court has granted us 14 days for appeal, which might lapse before we have the documents relevant for us to pursue further. Then we kindly request the court to order that the documents and the proceedings that we'll be looking for be typed and be available to us on priority basis. I'm alive to the backlog that is at the typing pool. Your Honor, with your kind pen, once that pen writes that it's on a priority basis, we shall be able to jump the queue. Your Honor, we will urge the court to order they be returned to him. That's all for now, Your Honor, unless the state has it and my good brother has any other issue.
Your Honor, we're indeed most obliged by the sentence. Will be used in the settlement of the penalty that has been imposed by this honorable court. That's all. Your Honor, further to what I have indicated to the court, the second convict has indicated that the balance of the cash bail be returned to her. It's 200,000, and I'm seeing there's a penalty of 100K. Okay, thank you. Most obliged, Your Honor.